Everyone. Hi, good evening. Thank you for joining us today for another episode or segment of Tenant Thursdays. Today's video is a very special one. We're creating a continuation of a video that we did on October 8th for the Just Housing Amendment. In that video, we discussed the amendment that was added to the Cook County Human Rights Ordinance that protects people from being discriminated against based on covered criminal history. Um, and so in that video on the October 8th video, and it should be linked in the description of this broadcast, you'll learn about why that this law was passed and what it means and what it means. Today's video is gonna focus on how the law actually works. My name is Alex Escobedo, and I am the Communication and Events Coordinator here at the Lawyers Committee for Better Housing. With me today is Aileen Flanagan, Senior Attorney at LCBH, and she covered the first October 8th video, so it only makes sense that she's with us again for today's video. Thanks for being with us today, Aileen.
Hi, Alex. Thank you. Thanks for having me.
And before we proceed, I will be dropping some links into the description, into the chat box of this video. The first one that I'll post, the first comment is the link to the first video. So if you're interested or you missed it, you can definitely click on that link and watch it right after this broadcast is over. And I'll also be posting a second comment that it's a Google form essentially, but where we ask if you could provide your zip code or any ward, if you know the ward that you're in. That information just helps us understand what trends or concerns are more prevalent in your area, and that allows us to create better topics more tailored to where you are, that are more relevant to you. Um, with all that kind of admin shout outs and links talk out of the way, Eileen, how does this law change the way renters apply for housing in Chicago?
Okay, so just to kind of give a broad brush picture here, the Just Housing Amendment adds another category of people that are protected from having discrimination against them, from being discriminated against in their housing. And the new category is to protect people with covered criminal backgrounds or history that can no longer be considered to exclude you from housing. And so the way it, and last on the 8th, like you said, we talked about why this amendment was introduced and passed, and the types of just generally how this will be affecting housing and housing applications. But tonight we're going to talk about how it really affects renters. And so, Alex, the first thing that it does is it changes the whole application process for housing, because landlords can no longer include a checkbox on a housing application that asks whether an applicant has a criminal background. And they also can't tell people, just if you've got a criminal background, just don't apply because we're not going to accept you. Like if you get someone that tells you that on the phone, that's wrong. That's not true anymore.
Right. And so how does it actually work?
So the law actually works in a couple of phases. And so before the landlord can even accept an application fee, the landlord has to tell you a few things, has to tell you its selection criteria. How are they gonna evaluate an applicant? The next thing they have to do is they have to give you notice of your right to dispute inaccuracies about your criminal history. Like we talked on the 8th, sometimes this criminal record system it's not keeping good, accurate records. And you might actually be identified as having a record when you don't. It allows you to also, this process allows you to provide evidence of rehabilitation and other mitigating factors if there is a criminal background that is applicable to you for this application. You can introduce other information to ask that landlord to look at you like a whole person. And finally, they have to give you a copy of the Just Housing Amendment, the whole ordinance, the whole amendment, or a link to the Cook County Commission on Human Rights, which we'll describe and tell you about the ordinance.
And I know you mentioned that it does change a little bit of the way the whole application process. Can the landlord still perform a criminal background check under
So
the just housing amendment?
right. So yes, they can, and it's limited. Okay. So the Just Housing Amendment requires some specific steps in the whole screening process for all housing applications. And the first thing, if they want to conduct a criminal background check, they have to follow this prescription. So the first thing that a housing provider needs to do is perform a pre-qualification and allow you to make your application based on other criteria, and like your credit worthiness, your job background, how many people are living there, that kind of stuff. And if you pass that pre-qualification, then you move on to the second step, which is the background check. And this is the part where they can screen for the past 3 years of history of the applicant, of history with the justice system. Any convictions that are over 3 years old may not be used to deny housing applications. And if a conviction is found, the landlord must conduct something known as an individualized assessment. Then once that's done, then the landlord must provide the tenant with a notice, a written notice of the approval or the denial of the housing, and information about the right to dispute the denial, and a specific timeline that the dispute process has to follow.
Got it. And I want to take a brief moment to address if you're joining the live stream or you're new to Tenant Thursdays, if you have any questions about what we're discussing, please go ahead and put it into the comment section of the video. I am monitoring both the comments and if you post a comment or a question, we can always ask it to Aileen, and that way your questions are answered right now. If you have any immediate concerns that are not related to the video, I just posted a link to rentervention.com. Please go there for any legal information you may need, or if you have any pressing matters that aren't covered by today's video. Now, Aileen, I know that individualized assessment is something that was briefly touched upon on the October 8th video. So what is that individualized assessment?
So this is sort of a guideline to help the landlords, the housing providers, do a kind of a assessment, essentially, of the applicant to look at things that will help understand whether or not that tenant is going to be able to fulfill the responsibilities of their tenancy, or whether their criminal background would weigh against the favor of it would be too much of a threat to safety or well-being of people and property. So the individualized assessment includes, but it's not limited to, several sort of things to look at, such as the nature and severity of the recency of the conduct, right, related to the criminal history, the nature of the individual's sentencing, the number of convictions that the individual has, what length of time has passed following the individual's most recent conviction, and what age, right? What age was the individual at the time of the conviction? Or what was the individual's tenant history before or after? Was the criminal conviction related to or a product of a person's disability? That's really important because we don't want people who are disabled to be just systematically excluded from housing simply because they have a disability that led to some kind of interaction with the legal system. Has the applicant offered evidence of rehabilitation? Remember, that's one of the things that tenants can provide. And the example of evidence of rehabilitation, that would include stuff like completion of a returning citizens program, job readiness training, supportive services that assist the tenant with a transition back into society. So if you're involved with the supportive services person, that could write a letter for you. Completion of GED and education programs, reports from the correctional facility showing what, that the person is doing really well, did really well with programs in incarceration, employment or personal recommendations. So lots of things that a tenant can supply to say, hey, stop, take a second look. Let's not be rash. I am entitled to a second chance.
So what is the right to dispute, and how would a tenant dispute a denial?
So the right to dispute is an important part of the process, because if there's inaccuracies in the record, or or you feel that they weren't really assessing you and following the individualized assessment genuinely, those would be things to bring up. So within 5 business days of receiving the background check, the landlord must deliver a copy to the applicant in person or by certified mail or by text or by email. So the housing provider needs to make sure that the tenant applicant receives that background check. Once the applicant receives the results of the background check, the applicant has 5 days to provide evidence that disputes the accuracy or relevancy of the information related to the criminal background check. And then the landlord must, within 3 business days from receipt of the dispute information, give a written decision to the tenant that they're reconsidered.
So, of course, my next question is more of a follow-up to this one. What can a tenant do to say the landlord doesn't follow this law or they do some kind of violation? Is there anything that the tenants can do?
Sure. So this is a law, and that means that landlords and housing providers are required to follow this law. As we discussed last week or on the 8th, there may be some exceptions. So you want to have some good guidance with this. But I would recommend that you call the Lawyers Committee for Better Housing, our agency, because we're helping to enforce this law now. We feel it's important to greet returning citizens and provide and allow for housing. Housing instability is a very serious problem for returning citizens and can cause recidivism. And we don't want that for anyone. It's just bad public policy to allow this to persist. So the Lawyers Committee for Better Housing is committed to assist with this. So call us at 312-347-7600. And I know, Alex, you're going to post that information. Sometimes landlords don't know the law. Sometimes this is a new law that was passed in January, as you might recall from our last session. So many landlords don't know that they're not allowed to do this, and they don't know the specific, because you can see there's a lot of steps involved. So some landlords may not follow this exactly right now, or even know about it. So we can step in, we can assist, we can help educate landlords, we can start to help mediate this and have landlords consider your application properly in accordance with the law. If the landlord still refuses to comply, there are remedies. The tenants can file a petition with the Cook County Commission on Human Rights and explain that there's been a violation. The board has the ability to evaluate these cases kind of like a court case, assess whether or not the tenants have actual damages and give actual damages to the tenant, assess attorney's fees to the tenant, but also not to the tenant, but to the landlord to pay for the attorney's fees for the tenant if she needed help, and also assess a fine against the landlord. So if these are egregious violations, I'm sure the commission is going to start assessing fines for noncompliance. So it's really important to bring these cases forward so that we can kind of educate the entire community that this is a new way of assessing people and providing fairer access to housing.
Definitely, and thank you for all that information. I know you answered the question I was about to ask next, which was if there was any penalty for violating the law. So thank you for answering that. If you're watching and you have any questions, please go ahead and put them into the comment section, so that I can go ahead and ask them to Aileen and we can address any questions or comments that you may have. And as you mentioned, I have posted the phone number to LCBH. It is in the comment section as well, so you can always kind of copy and paste into your phone if you want to give us a call. And the rent-intervention link is also on the comment section. So if you have any immediate concerns, please go to rent-intervention.com. It is open 24/7, 7 days a week. So whenever you're in need, whether it's 2 a.m. or 2 p.m., you can always go to rent-intervention.com, and Rennie will be able to answer and provide you any resources you may have.
So
And I just
but I wanted to just interject something else, because the one thing rent-intervention hasn't gotten in place yet is the screening for these particular types of cases. So if you feel that you may have been discriminated against, if some application hasn't quite gone the way it should, you can certainly reach out to us by phone. And I think that's the best way to get screened and do an intake if you feel you might have been discriminated against improperly and denied housing because of this. It's probably a faster way to get the assistance.
Definitely, and thank you for that clarification. So, and as Aileen said, if you feel like you've been discriminated against, please give us a call. The phone number is there, and if you missed it, or you want to hear it, it's 312-347-7600. The phone number is 312-347-7600, and it's also in the comment section of this video. If you're watching post live stream, please still go ahead and put the questions or comments you may have regarding the Just Housing Amendment. I do watch these videos post live stream, whether it's over the weekend or next week, just to make sure that no one's had any questions or comments that we missed. So we can always reply to you offline as well. With that said, I'm not seeing any more questions coming in. I don't know if you have any last things to add, Haley.
Yeah, I can add one more point that I meant to add earlier. So when we talked on the 8th, we discussed some exceptions. And one of the exceptions was if there is a federal public housing program that has different guidelines about what kinds of history, what kinds of criminal involvement history would be permissible to deny housing. Illinois has a new House Bill 206 requiring local, and that was Representative Delia Ramirez bill, requiring local public housing authorities to adjust these policies to limit some of those exclusions and kind of follow the same individualized assessment process that Cook County Commission on Human Rights has already introduced into law. So this is kind of a moving, it's got momentum, a moving public policy initiative. And the state of Illinois is looking at this for public housing purposes. So if you are in public housing or you are applying for public housing or some kind of public housing program, and you feel that this may apply. But if you feel it doesn't yet, hang in there, because we're hoping that this bill passes and that we have a broader access to housing for all of our returning citizens, because housing instability, as I said, is very it's a very serious matter for people returning, and it contributes to a concept called permanent punishment, which is part of an entire look at the fact that people who have had interaction with the justice system are unable to kind of move on with their lives. They're barred from employment, they're barred from education, they're barred from housing because of these past problems. So we want to give our returning citizens a chance to restart their lives and move forward in a positive way, and reduce some of these barriers, and make housing first and foremost, make housing accessible to people.
Definitely. Thanks. And thank you for that last point. It's really, really important. I do want to take the moment to make an announcement and make an invitation to the people watching this video live and post. November 12th at 6 p.m. we will be hosting our fall benefit at 6 p.m. And I will also be posting that link to, if you're interested and you want to view the event, you want to attend, it will be completely virtual, so you can watch it from the comfort of your home. And that there is a registration, and I'll be posting that link shortly. So if you want to attend November 12th, since it is at 6 p.m., we won't have any Tenant Thursdays that day, but we do have Tenant Thursdays next week at 6 p.m. We are on every Thursday at 6, except November 12th for our fall benefit, which if you're interested to go, I will be posting that registration link. Since I'm not seeing any other questions coming in regarding Just Housing Amendment, thank you, Aileen, for taking the time this evening to talk to us about this brand new law that's really, really important.
Thank you for having me, Alex. And I encourage everyone to think about this, reach out to us later after you've thought about it, and hopefully we'll see you at the party on November 12th.
Definitely. Thanks. Have a good night, and we'll see you November 12th, hopefully, and next week on Tenant Thursdays.
Good night.